So this is section 5 in remedies, and we're dealing with practice issues related to injunctions. And we're going to talk a little bit about the process itself, because it's a bit of an unusual process and it's something you should be familiar with. And we've got a few good cases to look at as well, including Campbell Soup versus Giles, Republic of the Philippines, and the original Great American Chocolate Chip Cookie Company case this week. We also have two important rules that we'll talk about on Thursday. One is Rule 52, findings by the court, and then Rule 58 is the entry of judgment, that the court actually has to issue a separate order of what that judgment is. But findings under Rule 52, findings of fact and conclusions of law, we've seen it already once. We're going to look at it a little more deeply on Thursday. But in any non-jury trial, the court is required to make findings of fact and conclusions of law. For the most part, lawyers would submit those to the court as well. It's based on the evidence that's been introduced, such that it shows that the court has worked their way through the actual evidence and applied the law to it, such that that decision is reasoned and sound. And it gives the parties and their lawyers an opportunity to look at that to make a determination about whether they should appeal or not. But the first case we're going to do today is Campbell Soup Company versus Giles. And that's a First Circuit case that's from here. And it's in the district court, it was before Judge Gorton. So it's interesting that it's a food case. Do you know who Judge Gorton is? You ever hear the ads for the Gorton's fishermen, Gorton's of Gloucester? They do fish sticks and stuff like that. No? Well, that's who Judge Gorton. It's his family, and his brother was a senator from, I think, Seattle, Washington. But at any rate. And the process here was the Campbell Soup Company was seeking an injunction. And again, I've mentioned this before, and we'll see it at various times. Oftentimes, business disputes turn into this type of business competition litigation, where one company is trying to maintain its hold over their proprietary information, but also to prevent another person from having a competitive advantage. So we see a lot of litigation like this between businesses and individuals, businesses and businesses, with respect to their intellectual property, their trade secrets, their client lists, their product. And so sometimes the lawyers are expected to assist in maintaining a competitive advantage, and sometimes it's on suits that are not so worthy as much as they done for business purposes as well. So that's something to think about. But businesses obviously oftentimes have a lot of money to throw at problems like this. But at any rate, just to get a little bit of the facts quickly. So this guy Giles had worked for 13 years at Campbell Soup, and he decided to leave Campbell Soup and undertake similar employment at one of Campbell's chief competitors. When he did that, Campbell promptly filed suit. They alleged that he would inevitably use or disclose various trade secrets in the performance of his new duties. And so what they sought was a preliminary injunction barring Giles from assuming his new position, at least for some period of time, and from otherwise making use of Campbell's trade secrets. District Court denies the request for a preliminary injunction, saying that Campbell's had satisfied none of the 4 criteria, and they call it 4, I call it 5. Why some courts call it a 4-part criteria instead of the 5 is that it has always been part of equitable law that you don't even get, historically you wouldn't get to go to an equity court when the courts were separate unless you could show you had no adequate remedy at law. In essence, money damages won't provide you that relief. So that is part of now our 5-part injunctive relief test, because there is no separate docket between law and equitable actions anymore. So when we're talking about seeking an injunction, we've said this before, you have to show that there's no adequate remedy at law, that the moving party is entitled to, is likely to succeed on the merits, that the party is suffering immediate irreparable injury. You want to balance the competing harms there. There's harm that is being suffered, at least if you listen to the moving party's argument about why they need an injunction. But any injunction that's granted is also going to impose certain hardships on the other side. So there'll be harms on both sides of this, and the court must weigh it. And then the 5th part of the criteria is that what, if any, public policy considerations, and how do they weigh in on this matter? Now, the court says that we don't even have to worry about moving any further with this because they haven't been able to show that they come close to satisfying that 5-part test. But what Campbell says on their request for a preliminary injunction is that we understand what the court is saying, but what is the process for assessing how those 5 factors lay and what evidence that we have to support it? And that's really what we're focusing on this week, is that process that's supposed to take place there. Campbell's is saying we want an evidentiary hearing. We want to be able to question witnesses. We want the other side to call witnesses. We want the opportunity to present evidence, to oppose evidence. They want sort of a full-blown mini trial. And they're saying if you're going to grant, or even if you're going to determine whether injunctive relief lies or not, then we want this evidentiary hearing. Now, there's a couple things to think about that evidentiary hearing. Think about the way the process works otherwise and maybe works generally. If you're seeking injunctive relief, you have to file your complaint. We've already learned that it has to either be verified or your request for injunctive relief has to be supported by way of affidavits, sworn statements as to what the facts are. And then that information is provided to the court. There's a motion for injunctive relief. And then the question is, so what happens after that? Is it simply the lawyers arguing before the court without live testimony, just simply based on the affidavits and the memorandum and the like? Or is there, and should there be more to that process? To the extent that you are either seeking injunctive relief, you ought to be prepared to provide that testimony if that's what the court wants. But understand that from the standpoint of affidavits versus live testimony, it's very easy for a witness to sign their name under it, even when it says under the pains and penalties of perjury. It's quite another thing to have to then have those facts tested by way of cross-examination under oath in a federal court, as this one would be, or even a state court, where you're then going to be challenged on what that affidavit says and your information by experienced counsel. And so oftentimes when people move for injunctive relief, they'll be quite expansive in their affidavits and providing information. And oftentimes some of that information, obviously as lawyers, we can poke holes in it. So if you're opposing the request for injunctive relief, you would probably likely want, at the minimum, you would want, to the extent you could have it, the evidentiary hearing. Why? Well, one thing is I'm almost certain that those affidavits won't stand up 100%. Not likely. Lawyers write the affidavits. The lawyer takes a little liberty with it, then because they know what should be in there to get it. Then the client or whoever's signing the affidavit, swearing to the facts, isn't always as careful in either reading or thinking about what that says and what the follow-up to that may be. And it's a lot easier just to sign your name to think about actually testifying. So the fact is that if you're opposing the request for injunctive relief, to the extent I can undercut those witnesses' credibility, I also get a sort of free crack at discovery, very early crack at discovery, because those witnesses are going to be under oath. I'll get to question them. I'll have then sworn testimony that I can use later on down the road to impeach them if the matter goes to trial. And to some extent, I can sort of feel out the skill and the strength of the adversary and their case. And I've got a crack at defeating the injunction at any rate. If I'm opposing it, there's almost no good reason why you don't want an evidentiary hearing, unless you're worried about the witnesses you may have provided by way of affidavits and have some of their information challenged and the like. But I would hope you wouldn't take those liberties, because anytime you're going to be filing those affidavits, you should think about where that goes down the road. Because to the extent you have taken liberties in writing those, there is no doubt when the client is deposed and challenged on cross-examination, the likelihood is they're going to point the finger at you and say, well, you wrote it. I didn't really read it. I trusted them to write what I said. This doesn't look accurate. And now it's probably not correct or appropriate, but everyone in the room is looking at you like you did something wrong. So you want to be careful with this. And that's why, if to the extent that Campbell's can get an evidentiary, is entitled, and that's what we need to focus on, to the extent Campbell is entitled to an evidentiary hearing, what the hell, why not? The other part of that as a defendant is, or generally it's a defendant, because you have to have a cause of action filed in order to seek injunctive relief. So it's usually the plaintiff who seeks it. But if a defendant has a counterclaim, they're free to seek injunctive relief as well. But at any rate, the other part of this is, I don't know that you can do what you're supposed to do. Can you actually put your evidence in when I'm making objections and when I'm arguing about hearsay and all the rest of it? Can you ask the questions? Can you actually provide the court with evidence that you've satisfied those 5-part tests? Can you produce the witnesses whose affidavits you provided the court? What can you put up now? Because a lot of lawyers like to think that they can, but when it comes time to actually doing this work in court, it's a lot easier to do it when you're sitting on the bench instead of having to stand up in court and actually do it. So Campbell's guy has absolutely nothing to lose by wanting an evidentiary hearing, and what their argument is we're entitled to the evidentiary hearing before you grant this injunctive relief. And so that's the question really, is under what circumstances is someone opposing injunctive relief entitled to an evidentiary hearing, or how does the hearing itself really take place? And that's what we're going to focus on with this case, because that's the question is, well, what can I demand, both either as the person opposing it, or if the court is reluctant to go my way, maybe as the moving party, I want to insist on an evidentiary hearing so I can flesh out what the defendant's position is and who's supporting it and what witnesses are likely to stand up and what aren't. So that's the legal question we're going to focus on, but let's focus a little bit on the facts first, because in part, when I read this case, I feel bad for Giles, because he's simply looking to do better by himself and his family, and Campbell Soup obviously has lots of money and lots of ability to spend money on their lawyers, and both of them actually have well-respected firms representing them and the like, so someone's paying lots of money on this case. So at any rate, the diversity suit is filed by Campbell's, and they claim breach of contract, misappropriation of trade secrets, unfair and deceptive trade practices, and then in response to that, and this is often the case, I've told you this before, best defense is a good offense. Giles responded by advancing a series of counterclaims, including one for intentional interference with contractual relations. As a practical matter, you want the plaintiff to feel that they've got some exposure going forward here as well. So if you can, consistent with Rule 11, plead counterclaims, you should, because it changes the dynamic. If the plaintiff has nothing to lose virtually other than the case itself, then there's a lot more a desire to go forward, and because I'm risking money, that's all, I'm not going to end up paying anything. To the extent that there is an action that they face, and he's got this, including one for intentional interference with contractual relations, then they have to be a little more serious about the risk that they're exposed to there in owing Giles, not just not losing and not having Giles pay them money. So Campbell says that there's various trade secrets, marketing information for the 95 fiscal year, and their fiscal year is August 94 through July 95. There's a secret project, secret soup project, involving a new product line scheduled to be launched in 1995. And then they tell you what some of this stuff is, and it's priceless, and it's not really the recipe to the tomato soup or whatever that Campbell's has. It's a lot of pricing, advertising, and there's especially a new advertising plan. And it says that they took some steps to be careful with respect to what employees got access to this information. And it says only 30 to 40 of its employees, out of a workforce of 40,000, were said to even know about this super secret soup project. Giles, because of his marketing, had been provided some of this information. And what they were worried about is any premature disclosure of the product would enable Giles' new employer to be able to undercut the potential impact of this. I want to focus on footnote 2 here for a minute. It says, upon beginning work for Campbell back in 1981, Giles had signed a patent trade secret agreement obliging him not to use, divulge, or publish any of the company's trade secrets without consent, either during such employment or thereafter. I mean, that doesn't seem unreasonable. If you've been given trade secrets, obviously, no matter what, you can't use them. But then it goes on to say, and this is kind of interesting and telling to me, no non-competition agreement, however, was signed. Campbell's breach of contract alleged a violation of the trade secret agreement. So if he was such an important employee, why is there no non-competition agreement now that he's in? The only time this has really become a problem is when he wants to work for a competitor and take some of his skills and talents that obviously he acquired during the course of Campbell Soup, his employment there. He wants to take them where they are valuable to a competitor. But there is no non-compete, and to the extent that absent the non-compete, they're trying to restrict him from working for a competitor, to me, there is something unfair about that. Even conceding that, well, I can't give them the secret recipe to any of the soups, that's a given. But to the extent I know other information, having worked there, if it's not a trade secret, why shouldn't I be allowed to go work for a competitor who's going to pay me well so I can take care of my family and pay my mortgage and everything else? And even if there were non-competes, Massachusetts law has recently changed in that regard. We would still honor them under certain circumstances, but there is a concern about restricting someone's ability to work But nonetheless, even absent that non-compete here, Campbell Soup doesn't want Giles working for that competitor because it gives the competitor potentially a window into their plans that they don't want known. So Giles, his response is that I'm not giving them trade secrets, obviously, and the marketing information that you're talking about was no longer really confidential. And so why should I be required to sit out for what could amount to nearly a year's worth of work? I mean, if you think of for most people, if you were out of work for a year in the field where this is where you would be paid reasonably, how am I going to pay my mortgage? How am I going to put gas in my car? How am I going to do virtually anything that we all take for granted simply because I have to sit it out now, not subject to a non-compete that I agreed to at the outset, that I knew if I went somewhere that competed with Campbell's within whatever the area defined is, that I would have to sit out. But even without such a clause, you're telling me I have to sit out. So to me, we'll go through the 5-part test, but the equities seem to heavily, as I agree with the district court, heavily tipped in favor of Giles. Did you know there was a soup season? Because that's part of Giles' response here. He says, since the peak of the soup season ended in March or April, most customers had placed their orders up to 4 months in advance. There's really minimal room for competitive positioning this year, so let me work. So first of all, there is a soup season.
It's just cold weather.
Yeah, all right, it makes sense if you think about it. Never really thought. I mean, it's not our business, so what do we think? What do we know? But there clearly is, and what he's trying to argue is there's really no competitive advantage here. Likely, that would certainly get them to where they would be able to come close to satisfying the 5-part test. The district court weighed in when they looked at the request for temporary restraining order and the request for preliminary injunction as well. They said they believed, the district court believed, Judge Gordon believed, that Campbell had failed to establish a likelihood of success on the merits. There was no irreparable harm or injury to Campbell's, and barring Giles from assuming his new position would likely damage his career and damage him, and especially that's because there is no non-compete agreement, but you're asking us to ensure that he doesn't compete with you for some particular period of time. And this is despite saying, well, this type of new project could be qualified as a trade secret, but the marketing information of which Giles is really privy to, that's no longer confidential information. That's out there, likely out there, and he doesn't really know the details specifically of the project itself. He knows about the marketing plans, and on that basis, if he uses some of the what might be secret marketing information, damages would satisfy them with respect to that, so they can't show no adequate remedy at law. So then we get to what the test the court sees here as the appropriate test under Roman numeral 2. And they go past, they don't even look at no adequate remedy at law, but that is really the first test anytime we're in equity. But what they say is the movement, what we've said before, the likelihood of success on the merits for the moving party, the potential for irreparable harm. You know, I call it irreparable injury simply because it's easy to remember I, right? But it's irreparable injury or harm. A balance of the relevant equities. That means balance the hardships that are occurring here to either side. And then what, if any, effect on the public interest there is here. I don't see that as really of that importance here, other than unless Giles wants to argue, if we're in Massachusetts, you might as well. There is significant public sentiment. By that I mean the legislature and the governor against these non-competition agreements, but this isn't even one. But what I'm saying is, even in situations where there is one, the legislature and the governor have criticized it and gone to the point where the law has changed significantly with respect to non-competes in Massachusetts, to the point that I think the new provision in the statute is that if you're going to tell Giles, by way of a non-compete, for instance, he can't work for a year, then you got to pay him 50% of his salary. That has to be part of the agreement in advance in order to make that non-compete effective. So you can't just say you can't work. You're going to have to give him the opportunity to still be compensated to some extent, even if you're going to if you intend to restrict his ability to work for others. So the new statute has some strength for the employees in it that wasn't previously there. But that, I don't really think that this is significantly involving public policy and the like. So Campbell's obviously doesn't like this result because they want to make sure that their new project goes off successfully, and obviously it's a business problem for them. I don't know whether we're talking hundreds of millions or even billions with respect to Campbell Soup, but we might. And so they don't believe that the district court properly applied Massachusetts trade secret law. But they are also significantly arguing about, we don't like the procedure used here in deciding the five-part test. We think that they should have conducted an evidentiary hearing, and then with respect to those evidentiary hearings, the court could have made adequate findings. This is in Roman numeral 2, under Rule 52A, which requires the court, anytime they're issuing judgments without a jury, that they make findings of fact and conclusions of law under Rule 52. And so that's really what we're looking at here, is the question of, well, we know the court did not hold an evidentiary hearing. Must the court hold an evidentiary hearing on the request for a preliminary injunction? And now we're in Massachusetts, and we're going to see a little variation in as we move around the country a little bit on this. But what you need to be grabbing from this is the language where you can tell the court that not providing an evidentiary hearing under the circumstances is reversible error. And again, anytime the court has to give you a more formalized or lengthy hearing, they would like to avoid it simply because it slows down their docket. But to the extent that they're just deciding things on paper, that may be wrong under certain circumstances and require reversal. So look at the first part of the Roman numeral 2.2.3, the Arabic 2.3. It says, as this court has previously observed, an evidentiary hearing is not an indispensable requirement when a court allows or refuses a preliminary injunction under Federal Civil Procedure 65. We're going to read that Aoud case later. But so the first thing is, well, at least what they say, is that there's not an indispensable requirement to give you that evidentiary hearing. But there will be situations that would more likely warrant it than others. So what the court is doing, and sort of tried to indicate this to you, it says they're balancing the balance is between speed and practicality, right? As a general matter, when people coming in for injunctions, they're saying that there's some urgency to the situation because they're suffering immediate and irreparable injury. Practicality, it's not always easy to get multiple witnesses into the courtroom for the hearing and to move forward like that. So speed and practicality, but obviously if we're talking about people's lives, as we are with Giles, if we're talking about millions or hundreds of millions, perhaps even billions of dollars, as Campbell's would argue, and all of us would say that they should make sure that their judgment is accurate and fair. And that's what the court's saying here, is we're trying to balance speed and practicality versus accuracy and fairness. And so there is some significant weighty issues that are involved in that, but you would think that speed and practicality shouldn't win out over fairness and accuracy. But what they say here is, at least in significant part, we will entrust it to the district court's discretion. Okay, but it can't be entirely discretionary. The district court itself should have guidelines as to where that line would be drawn between when it's okay to grant that preliminary injunction or deny it on the basis of the papers presented. And understand what the papers presented and the oral arguments would likely be. So the moving party is seeking the injunction. They either have the complaint, may be verified. They have affidavits that are sworn to. They have their motion that would ask for the injunction. They would likely have a memo with respect to the law and the facts that would support the granting of that injunctive relief. The opposing party has the same opportunity to file counter affidavits. Likely going to file a memo in opposition saying why the law says that the other side loses. And then likely, certainly on a preliminary injunction, and even on a TRO, if the court is doing it with notice to the other side, the lawyers would get an opportunity to come in, present their arguments to the court, and the court would listen to them. And then, based on all of those submissions and the oral argument, the court, as a general matter, would likely decide whether the preliminary injunction is granted or denied. It's not as if you haven't been heard, because that would normally be the process, but there's no evidentiary hearing in the process I just described. So under what circumstances, when all of that first part of it takes place, am I entitled to argue that I get, in this set of circumstances, I get an evidentiary hearing, even though they've said it's not always an indispensable requirement? Well, that comes into the middle of that same paragraph where they said it's not indispensable. It says, to be sure, when the parties' competing versions of the pertinent factual events are in sharp dispute, such that the propriety of injunctive relief hinges on determinations of credibility, that's where you should be looking at evidentiary hearing, because affidavits alone are not likely going to satisfy the test for injunctive relief. Anytime you can argue that the credibility of the witnesses is in sharp dispute, that says jury, or at least hearing, trial versus judge. Versus papers alone, right? You can't tell someone's credibility generally by reading a piece of paper. That's the whole idea about rules of hearsay and everything else. We want the witness on the stand, sworn, looking in their eyes and trying to gauge whether they're being truthful or not. So whether you're opposing summary judgment, whether you're seeking a evidentiary hearing on injunctive relief, to the extent you argue credibility is in question, then there's a greater likelihood that you should be entitled to that evidentiary hearing so that the court can assess the credibility of the witnesses. When you're opposing summary judgment, so that the jury can assess the credibility of the witnesses. When you're asking for the evidentiary hearing, so that the court directly itself can judge the credibility of the witnesses. And again, as I said, it's pretty easy to sign your name to an affidavit. It's a little harder to get up there and then withstand that scrutiny that you have said was the truth. It's oftentimes just simply not going to fully stand the test of that examination. There were liberties taken, or there are omissions within the affidavit that would change the context of what you've said. There's gonna be more that will come out if we get that evidentiary hearing. What we've gotta argue if we want an evidentiary hearing on the preliminary injunction is that the pertinent factual events are in sharp dispute, such that we shouldn't be proceeding on affidavits alone because credibility of the witnesses is key in the case. So let me ask you about, let's talk a little bit about that. So what are the pertinent factual events here really in such sharp dispute that we can't decide this case in essence on papers? So that's what then the court actually takes a look at here is, well, how did our process work in this case? And did the court offer them a fair opportunity to be heard, right? And that's the key here, is that there needs to be that fair opportunity. And the question is, well, how sharp is the dispute? What are we really worried about here? You know, one is saying red light, the other saying green light, and there's only these two witnesses. Well, that sounds like a case that we better have an evidentiary hearing on. But how far apart are we, and what type of process, what type of due process with respect to that ability to be heard were you afforded here? And so look at what the court describes as the submissions and the like. First, it is apparent Campbell was afforded a fair opportunity to present relevant facts and arguments to the court and to counter the other side's submissions, right? A full evidentiary hearing doesn't necessarily need to be conducted in open court. What they have to do is offer the parties a reasonable opportunity to put forth and oppose the disputed evidence. It says over the course of 18 days, Campbell submitted an abundance of material. The verified complaint we talked about, that's required under Rule 65. 3 initial affidavits in moving for their request for injunctive relief. A total of 7 reply affidavits. Reply affidavits, in essence, are attempting to counter the affidavits that the defendant then filed opposing Campbell's request for injunctive relief. And it says on 2 successive occasions, so they got 2 cracks at filing those reply affidavits. A legal memo, 4 letter briefs. I want to talk about that quickly. Excerpts from a treatise and copies of pertinent case law. 4 letter briefs. Some lawyers believe that it is okay, and it can be okay to submit what they call a letter brief. So after we have the argument, some lawyers then will submit a letter to the court. It's a mini little brief, a couple pages, describing, you know, this law or that case that came up, and maybe giving them some additional information, or saying, you know, this additional information has come to light. In this case, the court should be aware of. I have a little bit of a problem with it because to me it's too informal of a process. You really shouldn't be writing directly to the court, I don't think, unless it's in a brief that then, and the other side is given, even in a letter brief, an opportunity to oppose it. Now, there are times where you will do it. I think, though, when I see 4 letter briefs, I think if you did one, I could understand it. There's no good reason for you, on a preliminary injunction, for you to have submitted 4. It's because, to me, what I'm telling you is, it's a rare occasion that you should do it at all. I have no reason to understand why you should do 4. There's no good reason. Now you're pestering the judge, and I think many judges would see it as that. Even though what I'm telling you is that this is much more of a common practice in federal court than it is in state court. I've never seen it done in state court. I've seen it done a lot in federal court. I don't care for it, because to me it's too informal of a process, and the rules don't really specifically provide for it. Sometimes the court will ask for it, and that's a different situation. But to me, I think they're taking liberties with the court's courtesy here and accepting them. That's 4 letter briefs is just to me, ridiculous. But, and what I'm saying is, you should not do that as a general matter. If you come across some extraordinary precedent that just came out today that bears significantly on the case, well, then you probably should. But it still doesn't necessarily need to be done by letter brief. You could request to file a subsequent brief because of the new precedent. Sometimes, though, that is how we would do it. Is, we bring to the court's attention the case the Mass SJC just decided today, bears directly on point, and then obviously provide the other side a copy so that they can respond to it and tell the court as well. But to me, that's excessive, and that's taking advantage of the courts being generous about it, because there are some judges that it would kill you for that. And to me, it shows just a little bit of disrespect to the court to take advantage of the court's good graces by that fashion, which the rules don't provide for letter briefs anyway. So to me, you've decided you're going to circumvent the rules, and not just, and if you do it, it shouldn't be done more than once, because especially in the First Circuit, we have local rules as well. So in addition to, your federal rules of civil procedure, we have local rules. And if you don't comply with the local rules, whatever you're filing will be rejected, will be sent back. Whatever motion you've asked to be heard will be denied. The local rules, especially in the First Circuit, most circuits, but especially in the First Circuit, must be followed. And so you want to be careful with that. And so then the court also gave the moral argument on two different occasions. One, when they, ex parte basis, sought the temporary restraining order, which again, to me, that seems kind of cheap in this case, because they knew who Giles was. He was an employee for 13 years. This was not the type of emergency situation where you had to go in without notice to Giles or his new employer, but they're not a party to the case. Giles could have been told, we're going to go in to get an injunction, we're going to try and get a TRO Tuesday afternoon, you ought to be there. And to me, you didn't need to do this ex parte. Again, I think they were trying to blindside him and take advantage of the situation. I think the court saw it as such. So they got the chance to present on an ex parte basis, and then during a nearly hour-long session attended by both parties, they were able to submit, their papers had been submitted, then they were prepared, then they were able to argue for some time. So the question is, and this is why, is this sufficient to provide the court with enough of a record such that the court could reasonably go through those 5 factors and make an informed and likely appropriate judgment on the case? Or is Campbell's right that no, this is in such dispute that Campbell should have got their evidentiary hearing? And so we're, now off in the Court of Appeals where they're taking a look at it. And the court really did carefully look, and so did the appeals court, carefully look at what Giles' position is. Look at footnote 7. The mid-level sales position held by Giles at Campbell and now at Pet is in sharp contrast to this other case where he was a senior executive at PepsiCo or whatever. Think about what Campbell's is doing to what it says a mid-level sales position. I don't know how he's paying his lawyers here, right? Mid-level sales position, he was represented by Warner and Stackpole. They weren't cheap. And Deckard, Price, and Rhodes, with Campbell Soup is plenty of money. So they're all set. But he's represented by Warner and Stackpole. I doubt, but maybe Pet is paying his legal fees here. I don't know why they necessarily would. They're not a party. They're not required to. But I would imagine they may have been kicking in something here, because he went through the district court. That's tens of thousands of dollars a there, or maybe at least between 10 and 20. And now he's in the appeals court, and he's looking at least the same. And obviously, he needs to spend this money to keep his job. But how many mid-level salespeople have this type of extra money to fight the giant Campbell Soup? And certainly, obviously, if there's an evidentiary hearing, that would take even longer. I mean, Campbell's is flexing their muscles here and trying to make this so expensive and difficult that, you know, maybe Giles will settle, or maybe Giles will decide to do something else or go work for someone else. In any event, under those circumstances, Campbell's wins. And that's part of what the concern you should have sometimes about this is that, is it a legitimate business dispute, or are we being used here as pawns for business advantage? Just like we saw in the Crash Dummies case, which I think also there was a question of whether it was just business or whether there was a significant legal issue that deserved to be heard. Now, Campbell's is right. This whole issue about an evidentiary hearing is a significant legal issue. The question is, should they be entitled to get it in this circumstance, or are the facts not in such sharp dispute that we don't need that evidentiary hearing? And at the end of the day, this court had no problem finding that they weren't in such sharp dispute, and that the process the court followed here under the circumstances was sufficient to give Campbell's a reasonable airing of their grievance, such that the court could make a determination as to the likely correct winner. Now again, on preliminary injunctions, they happen relatively early. They aren't dispositive of the case in its entirety, right? They're based on a relatively small record. They happen in a relatively quick period of time. They are probable outcomes. We're going to see that that's the language the court often uses. Probable outcomes a year from now as to what will ultimately happen with the case. But you brought it before us because you're saying that you're suffering immediate irreparable harm, and that harm needs to be alleviated. But just because you win or lose the preliminary injunction doesn't mean down the road at actual trial that you will lose on that matter. At any rate, the court feels that the evidence before the district court was sufficient to support a conclusion that Campbell was unlikely to suffer irreparable harm in this regard. I mean, if you think about it, they may have suffered some harm as a result of Giles moving to a competitor, but to me, some of that's self-inflicted. You didn't have a non-compete. Now what you want to do is use your trade secret agreement to act, in essence, as a substitute non-compete. That's not fair to Giles. And look at the language they say. We reiterate that what was emphasized in Aoud. Even where Rule 65 fact-finding is desirable, it is designed to be tentative, preliminary in nature. The web of conclusions upon which a PI rests are statements as to probable outcomes, nothing more. Because until we actually have a full trial on the merits of the case, we don't know what at the end of the day what the evidence will be, or what the law says should be done with respect to that evidence that's received at that point in time. So when they're not guessing, but estimating as to what the probabilities are, that's the way that process works. Now, last thing, Roman numeral 3. Campbell's also asked to impound all appellate papers because they're saying there's confidential information contained and that should be free from public disclosure. Now, this is something we fight about as well. I would say the biggest reason the Kaepernick case settled with the confidentiality provisions within it is that the NFL didn't want some of that information to ever reach the light of day. And so it's a business decision, and a lot of businesses make just that decision. A lot of times businesses insist on confidentiality agreements, not just at the end of the process by way of settlement, but definitely if any significant settlement has confidentiality provisions in it these days. That's not a problem. You negotiate for it, you agree to it, contractually then you're bound by it. And usually, by the way, there's language in there except upon court order or something else, right? Because obviously if the court orders, some other court orders you to produce the settlement agreement or produce the information, or you're deposed, and the court says, and if you don't give us the information, you're in contempt, there has to be language in there, sort of a safe harbor language in there. But this language here is what I want to focus on just quickly for you. A lot of businesses want confidentiality agreements during the course of the litigation. I generally oppose those agreements. First of all, part of the reason is because the courts are opposed to it. The whole idea with respect to the First Amendment in our court system is that those papers and those proceedings should be open to public inspection, right? That the public should know what's going on in our courts and should be able to examine the legitimacy of our justice system. So even if businesses want confidentiality provisions, it's oftentimes going to be cloaked like this, that it's trade secrets and the rest of it, but it's not. They oftentimes want to keep their dirty little secrets secret. And so, you've got to be careful agreeing simply to that it's a that whatever confidentiality provisions they're seeking, because to me it's not in a plaintiff's interest that you keep those matters that come up through the course of litigation secret. These days the courts are not automatically, as they one time were, simply rubber stamping your confidentiality agreement. We're talking about during the court process, the gathering of the discovery information, your filing of motions with exhibits attached to them and the like. There are some that want all of the stuff filed under seal because they don't want anyone to see. Take, for instance, you have a significant discrimination case, right? I've seen it where they've asked for it then. For what? It's not my interest to keep your dirty little secret about your discrimination. It's not in my client's interest to not allow that information to be there for public inspection. Frankly, it's in their interest that it be there, because maybe others would put pressure to say, do you see what they're doing in that case? But at any rate, if there's others that are affected in some way with similar practices, they should know how they might be able to redress it as well. And so what I'm trying to caution you about is that they would oftentimes argue that they will argue that they need it and they want it, and we won't pursue discovery or provide discovery without it. What I'm saying is, don't be afraid to say, well, we'll take it to the judge then, because I'm not agreeing. There's, if it's the secret formula to Coke, okay, but a lot of these are business practices that aren't secret, and that especially if you're handling some of these cases. There's no real business practices at dispute. You just don't want them to know what your folks did here. And our process is that the First Amendment provides access to the press for that information. And whether it's a civil case or a criminal case, they should be able to have access to it. So here, the court actually in the First Circuit is looking carefully and saying, obviously, the confidential information should be properly withheld from public disclosure, but then they say the only information conceivably falling within that category are the few details provided about the new project. Nothing in the marketing information is so sensitive, and so while we will prevent some of this, at least for some period of time, from being allow it to be filed under seal, that's not going to be very long, and that is the practice of all of our courts now, really, is again because no one wants their divorce information publicly available, because it's oftentimes a lot of dirty little secrets. That's too bad. Is it sensitive information? Is it confidential information? Yeah. Is it information I'd rather have people not know? Sure. But it's not the way that's not the way our process works. Our process says that the public has a right to know what's going on there. So I'd be careful about that, and I think the court is careful here in trying to really determine, is this Campbell simply wanting to keep their business private, or are they really, do they have confidential trade secret information that the court is obligated to protect? And I just want you to be a little bit mindful of that, because it's a significant question that comes up a lot in business litigation too. And lastly, I want to say this about federal court. When you file papers now, complaint, whatever you're filing in federal court, there can't be personally identifying information in there. I mean, your name is fine, but no dates of birth, no social security numbers. If you have either exhibits or your pleadings contain that, they're going to reject it and send it back. So what we do try to protect individuals' privacy so that it's not stolen and used God knows where. So some of that personally identifying information is prohibited from being filed, but beyond that, the First Amendment does give us that right of access, which I think is appropriate. And I want to caution you as new lawyers that a lot of these business lawyers are going to blow smoke and tell you, well, it's all confidential information, and as long as you agree to a confidentiality order, we'll give you, they're not going to give you what you want anyway. But you don't have to agree to the confidentiality order either, unless it's truly trade secret information and the like. Let's talk about Republic of the Philippines versus the New York Land Company. And there's some procedural stuff I wanted to ask you about here, and there's actually a lot of interesting procedural stuff going on here. But first, there's they did enter the preliminary injunction appointing Cushman and Wakefield as a receiver. So what's a receiver? Oh, you got it yet?
It's a person that is where the court would appoint somebody to delegate the assets of the company or corporation. To what I remember.
The receiver actually, it's an extraordinary remedy. What the receiver does is, in essence, take control of the corporation and can do whatever needs to be done to carry out the court's orders as the receiver. So if I have to even liquidate all the assets of the corporation, then I am able to do that. So the receiver has extraordinary powers, and it's used with corporations, but it's obviously not something that should be done lightly. It's such an extraordinary remedy with such significant powers that the court has to be certain, virtually certain, that there's no other alternative available, because the powers of a receiver are extraordinary, and that's why they're going to back off this a little down the road, because this was done pre-judgment. A lot of times, if you're going to do a receiver, it's going to be post-judgment, because what if you're wrong, right? What if you're wrong? You appointed a receiver pre-judgment. As it turns out, the other side loses. There was no reason to do that. So you've got to be careful. Usually, if orders of the court have not been complied with, post-judgment, or judgment even for money that has not been satisfied, at some point in a subsequent action, the court might well appoint a receiver to liquidate the corporation if it's a money judgment, or to carry out the court's orders. I think we saw it. I think it was a receiver when they appointed over the Boston Housing Authority at one point to prevent the discrimination that was happening with the Boston Housing Authority. I think it was a receiver appointed to carry out the court's orders on Boston Harbor so that the pollution of the harbor would stop and the waste treatment plants would stop just pumping raw sewage right into Boston Harbor. And it might have, and I think it was a receiver that desegregated the Boston public schools. Those are extraordinary orders from the court, because the people who are supposed to be running the entity are not doing what the court's orders have done. So understand that here what they're worried about is, obviously, we've got buildings worth a fortune in New York City, And if the receiver doesn't pay the mortgage, if we don't take care of this, by the time this case gets over, there'll be nothing left. So it says, okay, Ray?
Are receivers lawyers?
Oftentimes receivers are lawyers. They are not necessarily required to be. I think here it was the Cushman and Wakefield was a real estate company, but oftentimes the ones I mentioned, Boston Harbor, the BHA, and what was the other one I told you?
Desegregation.
Oh, the Boston Public Schools. I think they were all lawyers. I'm trying to remember who. It was Harry Spence, Judge Paul, redhead guy with the big bushy mustache. And I forget who was the receiver in the Boston Public Schools. I forget who that was. That might have been an educator, not a lawyer. But at any rate, it says the Canadian Land Action sought to intervene as of right. What's an intervener? What's an intervener? How's that work? Go ahead.
Is it a third party who comes in to assert a right that they have in the case?
What gives them the right to do that? And that is correct. An intervener is a third person not already present in the case who seeks to come in as either a plaintiff or defendant in the case.
If they can show a substantial stake or right in the claim.
It's close. Right, that they have an interest in the claim that is not presently represented by one of the parties there, and that as a practical matter, the resolution of this case is going to affect their interest that is being litigated. It's a high standard to try and say you can intervene as of right, but the fact is sitting out on the sidelines may be worse. So a lot of times, especially where you've got a lot of moving pieces in a case like this, you're likely to see interveners because there's so much at stake. If I wait till this is over, there might be nothing left when by the time we hit the end of the road. And so, again, there's a whole bunch of other things here, but this case is focusing on the issue for this week is how does this process work? Because really, when they're appointing a receiver, in essence, they're doing it by way of this injunction. And so, should the judge have allowed for an evidentiary hearing before issuing this order? And so here's the first thing that I need you to focus on. My book, it's page 37, it's Arabic 3. It says, appellants also claim that they should have been an evidentiary hearing before the order was issued. However, our record indicates that while they had the opportunity, they never asked for such a hearing. So here's the first thing. If you want it, demand it, right? If you're going to demand it after the fact and say, oh, we should have got one, well, forget it. You got to ask. You know, we did this over in Salem one time. The other side they were trying to get an injunction. We said, Your Honor, we're here, we're ready. Start the trial, right? Okay, let's proceed. We're good to go. My witness is here. Let's go. And we had a little show trial for about 15 minutes, and the other side stumbling over all this stuff. Judge suggested, why don't you go back out and see what you folks can agree on, what you can disagree on. Don't be afraid to insist on your rights. And this is the same thing I've said to you guys in evidence, when I had some of you in evidence. If you don't object or you don't ask for something at the district court or the trial court, don't expect that someone on appeal is going to help you out. They're going to dump it back on you over and over again, right? They didn't object at the trial. They didn't make an offer proof at trial. Well, you're done. You don't ask, you don't get in our business, okay? And that's what this is saying, is that you want something, you better demand it. And they're going to try and bully you out of it at times, and that's the way judges work. But if you demand it, you got a better chance of getting it. And if not, they're going to say, well, you might have got one, but you never asked. And now your client's going to be looking at you saying, well, why the hell didn't you, right? And understand that that's the way that works. And this is the Second Circuit we're in here now, so this is New York. We recently held that on a motion for PI, where essential facts are in dispute, there must be a hearing. and appropriate findings of fact must be made. So this isn't just saying sharp dispute, they should, but this language here I would use to argue there must be a hearing. Now, they modify it a little bit down the road here. It says it's not a rigid requirement that oral testimony be taken on a motion for PI, but that top language is pretty strong, saying, okay, give me my evidentiary hearing. And again, a preliminary injunction is a very powerful order, as this case points out. There's really no reason why you shouldn't get the highest level of due process there. And all we're saying is swear the witnesses in and let's have an opportunity to cross-examine them. And then lastly, Note 4 talks about what this whole idea is about those findings of fact under Rule 52 and 65 that are required. It says, these rules require a district court to set forth the findings of fact and conclusions of law which support its order and to provide its reasons for issuing an injunction. It's twofold: to aid the trial court by requiring it to marshal the evidence before it, and more importantly, if the case gets appealed, for the appellate court to look at those findings and conclusions on appeal to make sure that the judgment is well-grounded. We're going to talk a little more about Rule 52 next time, but that language is important. You don't want the court just simply saying, I issue the injunction for Ray. The defendant is required to stop doing X, Y, or Z. That may be what the court wants to do, and that may be what the court does. It's important to establish how you got there, right? And that's what findings of fact and conclusions of law does. It makes the court take a step back and really make sure that the evidence supports what the court wants to do and that the law supports what the court wants to do. That's why findings of fact and conclusions are important. We're going to read a case, by the way, that says it's not necessary that the court do it in writing. There are sometimes the court will do it, they'll orally read their findings of fact and conclusions into the record when they announce their judgment. As long as there is that record so that we can see what the basis for the court's judgment was, that's all that's needed. And we'll take a look at that at Rule 52. But it's even more important, though, that there be a basis for the court's decision that is available for review, and so that you can look at it, even if you disagree with it, you can look and see what the supporting facts and reasons are for why the court did what it did. And that's the idea behind 52. I will talk to you next time.